Hi everyone. Good to see you, and thanks very much for joining our second lunchtime lecture today on managing stress in high stakes litigation. And one of the reasons why we wanted to do this webinar was because as litigation solicitors, uh, not only do we find ourselves guiding our clients through legal strategy, the black letter of the law, and how their case might progress, but we inevitably and invariably find that we're being asked to, in many ways, be a litigation coach, and to help our clients manage their mental health. For those litigators on this call, you will know very well that a litigation can last between 1 and maybe 3 or 4 years. And that's a long time to be working with a client. And for clients, that's a long time to be working with your solicitor. So in many ways, you start collaborating with each other and you become a bit like a partnership. And as part and parcel of that, you're not only dealing very mechanically on the legal aspects, but you're also dealing very much on the very human to human level and the stress that comes with stress with high stakes litigation. So the purpose of today, and it's not going to be more than 15, 20 minutes, is just to talk about some of the strategies that we guide our clients with when they find themselves litigating through the courts, and how they can best manage that. So thank you all very much for joining. Now, I personally feel, having been a litigator now for about 15 years, that the stress that comes with litigation is the most underrated discussion point when a litigation happens. People just don't talk about it. And it has such an evasive effect on how a case can potentially run. Litigation affects not just legal strategy, but can help affect sleep, decision making, relationships, confidence, and overall well-being. So it's very important, in my view, that litigants and solicitors are managing not just the well-being of the case, but the well-being of the human body whilst working on that case. So I think that's really what today is going to be about. And it's really important that, when decisions are made when litigating, the body is at its healthiest and the mind is at its healthiest, because nobody can make sound decisions when they're under pressure or under stress. And litigation is about navigating different decisions at different times and deploying different strategies. So the first thing I wanted to really do is talk you through the life cycle of a litigation and how that might impact stress. So, for those of you who are litigation lawyers, or those of you that have found themselves on the wrong end of a litigation, they may receive a claim form. Now, that claim form is actually the start of a litigation, it's the start of a claim. And that can be the most difficult time for a litigant because it could be unexpected. The opponent could be a relative, it could be a friend, it could be someone that you've had really positive dealings with historically, and all of a sudden you don't have those positive dealings with because they've gone and sued you in court. And I often find that my clients, they find themselves in panic, perhaps anger. They catastrophize. They think about what is the worst case scenario in all of this. There could be a degree of sleeplessness or mental paralysis. The first 48 hours when a claim has been received is usually the most stressful in the life cycle of a litigation, because it can quite often be pretty unexpected. Yes, you may receive pre-action letters, but it's quite a different undertaking when somebody has actually pressed the button, paid the court fee, and has started a claim. And the first thing I do when my clients come to me in a panic is I'll say, look, think about it like this. What is the best case scenario that can come out of this litigation? What is the worst case scenario that can come out of this litigation? And what is the most probable outcome? And what I can say, and you have to be careful that you're not generalizing, but the vast majority of cases don't go all the way to court. Many of them end up settling on quite favorable terms to suit the parties. So it's always important that you think about worst case scenario, best case scenario, and what is most likely to happen. And on the worst case scenario, coming up with a strategy as to how you will deal with that if the worst case scenario were to kind of materialize. So let's say you went to court and you didn't succeed and you had to pay your legal costs and pay the costs of the other side. how could a litigant best manage that is incredibly important. And it's really important that you're thinking about the worst case scenario from the outset and how to manage that because that does make the whole process a bit more manageable. So, preparing for the worst, but hoping for the best is usually one of the first things that I would advise and I generally kind of guide my clients on when they come to me in a bit of a panic because they've been sued. But also always remembering that the worst case scenario probably won't materialize quite as bad as it may you may expect. The next thing that causes a lot of stress right from the beginning is that litigants, clients, don't know what the litigation process is. They sometimes think that, oh my goodness, I've received a claim form. The next thing is I'm going to find myself in court. But what they forget is that English litigation, particularly, is very procedural. And there's lots of different stages that have to be complied with, whether that's disclosure, witness evidence, pre-trial checklist, pre-trial hearings. There's quite a long process from receiving the claim to the trial, and so much can happen over that process. So it's really important that clients are aware of what that process looks like, what are all the different stages, what, as best as he possibly can, understand what the costs are for each of those stages. Clients shouldn't think that you have to pay all your legal costs upfront right from the outset. It just doesn't work like that. Quite often, legal fees can be split up over several months or even years. And to understand where in a litigation there are pressure points, because there are certain times in a litigation where you can potentially ask the other side to think about settlement, and timing is critical. So being clear on a roadmap, both a procedural roadmap and a financial roadmap, is probably going to be a very good exercise to do right from the outset because that will create a strategy and create calm. And I think that's very important at the beginning. The next thing is being very clear about disclosure. Now, for those of you who don't know, disclosure is a process where parties give the other party the key documents that are relevant to their matter. And I find that this is a very, very a stressful part of a litigation. And the reason for that is because it can feel very intrusive, highly personal. In some cases, you've got to give off emails that are in your inbox. I recently had a case where a client had to have their mobile phone forensically imaged, their WhatsApp messages forensically imaged. What that basically meant was that the lawyers had to copy their entire WhatsApp history, go through everything, and decide what was relevant to the case and what wasn't. And there's all sorts of photos in there, personal messages, things that you don't necessarily anticipate a lawyer seeing. So I like to ensure with my clients that they have done some sort of document mapping exercise very early on in a litigation. What documents are likely to be helpful? What documents are likely to be unhelpful? Make sure they're retained. Make sure you have mapped them out so you know exactly what it is that you're likely having to disclose later on during the disclosure process. Being in control and being proactive is the next best thing when you have to be reactive as a as a litigant. So you can't control when someone's going to sue you, or you may not necessarily control when you want to press the button and sue someone. But the next best thing is making sure that you've planned everything else out in those circumstances. So I think being as diligent as you can on the disclosure process is going to do a lot in terms of keeping matters relaxed. The second thing that I like to do quite often is when a claim arrives very early on, I like to almost put together a first draft of a witness statement. Now, for those of you who are new to litigation, witness evidence is not needed until quite later on in the litigation process. But as you know, human minds don't get better in time. So from the day a claim is started to actually drafting a witness statement could be several months or perhaps several years. So one thing I advise my clients is soon as a claim has hit your desk, think about putting together notes about your case. What is it that you are potentially going to say or do or refer to when it does come to giving witness evidence? It's a bit like journaling. It's getting your thoughts together, putting them on paper, and storing them ready for when witness evidence needs to be given. And it's incredible how therapeutic that exercise can be, rather than just letting kind of the story and the narrative play out in your mind over several weeks or several months. So, for those of you who are lawyers on this call, and if you're not already kind of advising your clients to potentially put thoughts onto paper, it's worth doing pretty early on. And if you are litigants and you're being sued and you haven't quite done that yet, it's worth doing. It's incredible how powerful that exercise can be. And it also allows you to focus on what documents might be useful for later on in the litigation. So it's a really good way to kind of keep the nerves calm early on. The next thing, just to kind of conclude on this point is litigation can last maybe 2 to 3 years quite often. It's a bit like running a marathon rather than a sprint. And it's not unusual for fatigue to kick in, both financial fatigue, mental fatigue, irritability, getting annoyed at your family, potentially getting annoyed at your solicitors. It's not personal. It's just after a little while of a matter consuming you, it gets to a point where you just do feel a bit fed up. It's very normal. So it's very important that you create in your life um, control mechanisms so the litigation doesn't become all consuming. It's easier said than done. I completely appreciate that. But for example, having a set time every day where you focus on the case, it might be after work for 1 hour or 2 hours, it might be during a lunch break, but having a time in the day where you let your brain focus on a claim that has been started or your claim if you've started it, putting the energy in, thinking about it, and then once you have finished that 1 or 2 hours on your claim for that day, don't think about it. Focus on your family, your hobbies, your well-being. Because litigation will stretch on for a number of years, potentially. And so it doesn't serve any use in allowing it to be so consuming. It's very important that you try to compartmentalize that litigation to avoid emotional exhaustion and sleep deprivation. And I think the other thing that I would say is, arrange times with your lawyers. Like lawyers are very busy by nature. They might call you when it suits them. And I think if you can arrange a time during that window where you're thinking about your litigation to have your call with your lawyer, that will also help compartmentalize matters. So not only are you thinking internally about your case, but you're also having a discussion with your lawyer at a time that suits you, providing it's during business hours, to think through your matter. I'd like to just talk very briefly about the power of settlement and resolution. Now, for those of you litigators, you will know this, but for you listening to this who are not litigators, the courts like resolutions. Judges, and however counterintuitive this sounds, are not big fans of people that are hell-bent on litigating. Now, the dichotomy is that as the litigation goes further on, parties can find themselves somewhat entrenched in their position and less willing and open to settlement. But I think that a solicitor and litigant should always be thinking about the right time to open up discussions with the opposing party. It is amazing how many cases we've had where a simple discussion between the lawyers or between the clients has resulted in a resolution, and actually the court proceedings have come to an end pretty fast. We recently worked on a $40 million claim in the English High Court, And despite having thousands and thousands of documents and hundreds of pages of witness evidence and the matter going on for 2, 3 years, it actually just took a conversation between both parties to instigate settlement proceedings, which actually settled within about 3 days of the first discussion taking place. So, whilst there might be a general tendency to be quite standoffish with your opponent who has gone and sued you or you've gone and sued them, don't lose sight of the possibility to keep the lines of correspondence and communication open. It can be with your lawyers or directly between yourselves, between the two parties. It is incredible what can happen when there is just honest dialogue between the parties. And I always advise my clients to not rule that out. It's very important the timing is right. You want to make sure that when you're settling, you're doing it at a time when you're in a position of good leverage, and you've really got a good story and narrative to tell at that point of settling. But don't lose sight of that. It is not a given that every claim has to go to trial, and most claims don't go all the way to trial. So please just bear that in mind. And even if a case can't settle in its entirety, it can narrow down issues, it can de-escalate disputes, and it can alter the direction of a litigation. So please don't lose sight of that. For those of you who are watching this and you're actually about to just go to trial, and therefore, you've already endured many months or weeks of a litigation process, um, a trial is there to give everybody a fair hearing. It can be daunting to be in the witness box, but it's very important that you're aware of what your witness evidence is. Your lawyers are not allowed to coach you on what to say and how to say it, but what you can do is potentially go on a training course about how to handle cross-examination. And for those of you who are interested, we can give you details of that training course. But being as prepared as possible is inevitably going to be put you in best stead ahead of that trial. It's not a test. A trial is not an exam. It's there to allow you to give your side of the narrative. And the biggest advice, I'm sure my litigation colleagues on this call will agree with me, is just be honest. Because those witnesses that are honest actually are very confident. They can't really get caught out because their honesty is shining. And it's those witnesses that try to be over clever, perhaps try to manipulate the facts or try to second guess what the next question is going to be at a trial, find themselves, stressing more than those that are committed to the truth. And the way you can best be committed to the truth at trial is by starting your journal or your draft witness statement very early on, because that's when your memory is going to be best placed, ready for that big day. So I hope this has given a bit of an insight into how a litigant or a lawyer even can manage stress around a litigation. I think it's very normal to catastrophize, and it's very important if you're feeling like that to think about the worst case, best case, and most likely scenario. It's very important that you are clear on the process, procedure, both legally and from a cost perspective. And if you can understand what the worst case scenario looks like and how you can manage that, then the whole litigation becomes a bit more comprehensible, a bit more manageable. And your lawyers can help you put together what a worst case scenario can look like and what a best case scenario can look like. Litigation is ultimately uncertain. It can it can feel like you're under a lot of pressure and can be very consuming. But being able to compartmentalize your litigation matter so it only occupies a proportion of your day or week to allow you to live the rest of your life is very important. And, I always say this, out of everything, your health is the most important thing, quite frankly. So ensuring that you've built in well-being strategies and tactics is going to be very important. I'd like to thank you all very much for listening. If you want to drop us an email with any specific questions or any questions that come to you afterwards, you can find our email address on our website, which is www.wyn.legal. Thank you all very much for your time. Enjoy the rest of your day and see you at our next webinar. Thank you.